Hi, it's Mike DelSignore here, Massachusetts OUI Lawyer. In today's video, I want to talk about what happens. You called the lawyer, you hired them, and they want to resolve the case on the first court date. Is that a good idea? Should you resolve the case on your first court date? Well, I have done it in occasions, but it's rare for me to resolve a case on the first court date. The reason why I discourage it, you don't have all the information about the case. You don't have any video. That takes time to get this information. So just a quick glance or reading of the report doesn't tell the full story of whether this case can be won or lost. We need all of the information from the DA's office. We need time to talk to any potential witnesses, get any medical evidence, to go over your version of what happened. So if you're resolving the case in the first court date, ask yourself, do you know if there's any video in the case? Have you had a chance to tell your version to the attorney? Have they had a chance to look at any medical evidence that you might have? And have they investigated the case fully before you've resolved the case? You know, breath test evidence doesn't always come in. There's motions, there's hearings. So just a reading of the report doesn't mean that evidence is going to come into court. You can file motions to challenge the stop, challenge any statements you made, and challenge the search of the car if there's alcohol found in it. So there's things we can do to make a case better. You might think the case is difficult, but legally, not all evidence comes in that's just written on the police report. So keep in mind that breath test evidence, it's an estimate of your blood alcohol. It's not a blood test, it's a breath test. So there are conversions, there are different scientific processes going in that come up with a reading that's not necessarily accurate. There's also some procedures that officers are supposed to follow, namely a 15-minute observation period. Many cases I see this isn't followed at all, and that the breath test shouldn't be admitted into court. So don't rush into a plea. If you took a breath test, it's a 30-day suspension. After 30 days, you can get your full license back. If you refuse, it's a 6-month suspension, but in some courts we can get to trial prior to the 6 months and you'd be eligible for reinstatement. So make sure you know all your options. If you speak to an attorney, they advise you to resolve the case quickly, or you tell them your story and you say, oh, I was drunk, I did terrible on the field tests, I just want to resolve it. And they say, fine, yeah, you can't win this case. That's not really in your best interest. Everyone who calls me thinks that they have the worst case in the world, that the case can't be won. And even people who admittedly had too much to drink have a lot of times have cases that can be won when you look at it, because it's not a matter of, you know, you might have made a mistake, and I'll be the first to say, if you think you made a mistake and you need alcohol treatment, get it voluntarily. It doesn't mean you need a criminal conviction. Standard of proof beyond a reasonable doubt is much higher than the moral standard of, well, maybe you made a mistake that night. So don't mix up the two. You might feel bad, you might think you wish you decided things differently. It doesn't mean you need to admit to a criminal charge. So keep those things in mind. Don't rush into a plea. Make sure you do all those things, that you give your lawyer your version, you tell them about any witnesses, and that they have a chance to have sort of a meaningful discussion with you. If they do, you want to resolve it on the first date, that's fine. There is some advantage. You save a little bit of time in the suspension, but in many cases, you're not going to have all the information. You're certainly not going to have a chance to do motions. You probably heard about the continuance without a finding. It's not going anywhere. You don't need to take it on the first court date. You can take it at any time. Really, almost in any court, they'll accept a continuance without a finding right up until the trial starts. So this can be done at a later court date. You might hear in court that dates are 6 to 8 weeks out. Might make you nervous, but in many courts, if you get a date that's too far out and you decide to resolve it, you can advance it and you can come in within a few days. So there's not a rush to make a decision. Don't feel pressured to make a decision just to get it over with. Often that's not a great decision for you. Now, especially if you have an out-of-state license, I get probably a call a month from people who hired other attorneys who say, geez, I thought my license suspension was 45 days. Now Rhode Island's telling me I'm suspended for 6 months, or Connecticut's telling me I'm suspended for a year. I need an interlock device. So keep in mind that if you have an out-of-state license, you have consequences in 2 states, both your home state and in Massachusetts. So it's something you should know. Information you should have from your lawyer about what's going to happen in the other state. It's not a good response, and frankly, if they say, well, I don't know, the state will do whatever they do. No, there's an answer to all these questions. Sometimes it's complicated, but there's an answer. It's not whatever, or I don't know, or the registries do whatever they do. So make sure that if you're charged with a first offense, you look into the case, you don't let the emotion of, I want to get this over with, I want to move on with my life, have you enter into a plea where you don't know the long-term consequences. You don't know if you could have won the case. You don't know how the court operates. Make sure you have all that information. If you want it, I'm happy to provide it. I talk to plenty of people. You can always call or text me anytime. My passion is helping people charged with OUI offenses in Massachusetts. Call, text 781-686-5924. My name is Mike DelSignore. I'm here to help anytime.